The Alberta government has received both criticism and praise for introducing Bill 13, the Regulated Professions Neutrality Act, otherwise known as Peterson's Law. This is after Dr. Jordan Peterson had to undergo remedial education because of some of his social media comments on gender pronouns. So the intent of the bill is to allow professionals like doctors and lawyers have the freedom to express their personal views while off duty without fear of reprisal, like being censored or by being punished by their regulatory bodies. So joining us from Calgary to discuss this further is civil rights lawyer Glenn Blackett. Glenn, great to have you with us today.
Yeah, thank you very much for having me.
Okay, so of course the Jordan Peterson story brought this to people's attention, but what have you observed in the legal profession when it comes to mandated training that some people call woke training, and how does this impact the way law is practiced?
So in Alberta, we've had mandatory training. It was called the PATH, and it was sort of a Indigenous issues training. It was actually something that was steeped in a particular kind of wokeness called post-colonialism. Your question as to how it affects the practice of law, effectively at the end of that training, what lawyers were invited to do was to help in a program basically to enhance the racial segregation between Indigenous people and other Canadians by helping create a system of Indigenous laws, Indigenous courts, and really a parallel system of Indigenous justice for Indigenous people. The theory being, according to post-colonialism, that it's actually Western systems of justice which are continuing to oppress Indigenous people. So we need to resolve that by getting Indigenous people into their own legal system. And
okay, so they'd have almost their own court.
Yeah, own courts, own laws, own everything. Yeah, which I, may be a good public policy or not, but seem to be odd subject matter for education from a legal regulator, because generally the lawyer's job is not to change the law. The lawyer's job is to take the law as written by the legislature and implement it. But I will say too that the mandatory training is a part of the problem, but the broader problem is not so much mandatory training as it is politicization of the regulators. So the Law Society is supposed to make sure that lawyers are competent and ethical so that they can observe their duties of loyalty to their client and their duty of loyalty to the law. Yes, mandatory training is one way to interfere with that, but a broader way to interfere with that is redefining competence, for example, which is something the Law Society's done. So mandatory training is a small part of the problem, but it's really just a symptom of a broader disease.
Mm-hmm. It sounds really complicated.
Yeah, sorry, I should be making it simple for you, but.
No, that's not what I mean. I mean, if you are the lawyer and you have to balance between these worlds, it sounds really complicated for sure. Almost like they'd have to have their own sets of law schools and lawyers and everything else. So it sounds like some people are welcoming of Bill 13, but you have some concerns with the current form of the bill. Can you explain that?
Yeah, I mean, so I'm a lawyer who has, on behalf of my client, Roger Song, has sued the Law Society of Alberta. And the basic premise that we're suing on is that the Law Society has no business in politics. That's not their job. Lawyers' job is to take the laws written by the legislature and implement it, not change it by the way we practice law. So that's my background. And so Roger and me have both been quite active at really encouraging the government to get politics out of regulation. And what the bill has done is, on the one hand, it seems to, and I don't even think it's effective at doing this, it seems to narrow the professional regulators' rights to censor off-duty comments by their members. And it seems to limit their rights to, well, it does in some ways actually limit their right to mandate education. But what it also does, and this is the problem with it, is that it really introduces the idea that, it introduces politics into professional regulation. So it actually, there's some sort of particularly noxious concepts. One of the noxious concepts is a thing called cultural competence. Cultural competence, according to the Law Society of Alberta's materials that are a little hard to find, is where the lawyer has a political agenda, and their political agenda is to make radical transformations in the justice system. So that's called cultural competence. The Bill 13 says basically that, well, regulators can't mandate education in cultural competence, but what the bill doesn't do is say that and should not be engaging in cultural competence in any other way. And so basically what the bill does in a sort of backhanded way is say that it's okay for a regulator to be pursuing cultural competence generally, as long as they're not doing it in particular ways. So the problem with the bill is that it further weaponizes the profession to pursue political objectives when the legislature should be doing exactly the opposite. The legislature should be prohibiting the regulator from pursuing political objectives.
Okay, so does the Bill 13, does it ban sanctions against professionals expressing personal views while they're off duty? Is that what it's basically doing?
Yes and no. It does ban some sanctions for off-duty conduct, but it doesn't ban every sanction for off-duty conduct. So there's still some sanctions that the regulators can pursue for off-duty conduct. And then the next question is whether or not it changes the existing state of law. Right now, there's already some restrictions on regulators censoring off-duty conduct. When I look at the bill, it's not obvious to me that it actually changes that law in any way. So if you look at the common law, and the common law basically says that regulators can only censor off-duty conduct if there's a sufficient nexus with the profession, basically. So, if a doctor goes into social media and says, I'm a doctor, trust me, I'm a doctor, and then spouts a bunch of medical misinformation, then the regulator, and I think that's kind of what happened in Amy Hamm's situation, the regulator can say, well, you've engaged your professional responsibility, therefore you've engaged the integrity of the profession, therefore there's a sufficient nexus, so we can censor you. When I look at the legislation, it doesn't seem to change that at all. So does it actually even narrow the right to impose sanctions for off-duty comments? I don't think so.
Okay. Does the bill still allow censorship of the expression of professionals' personal views while on duty?
Yes, it definitely does that. So, which is, I think maybe a bigger problem. Jordan Peterson, for example, was speaking in social media, off the clock. And so we're concerned that, well, why should we be censoring him in that situation? But I think, especially in COVID, your viewers may understand this. In COVID, there was also censorship of doctors on duty. So there was censorship of what doctors were telling their patients in the actual consulting room. And that can be a good thing or a bad thing, depending on whether or not that censorship is for the right reasons, right? So if a doctor is giving bad medical advice, a regulator should say, hey, you can't be giving bad medical advice and should probably do something about that. So some kind of censorship on duty makes sense. But if what you're censoring on duty is something that you're censoring because you have a political objective, again, so for example, during COVID, the regulators, the medical regulators wanted to make sure that all of their staff were giving the public health narrative, right? So that's sort of a political objective. So if you're censoring doctors on duty for a political reason, then that is a real problem.
Yeah, so that would be a doctor being able to share or not share personal views on effectiveness of the vaccines, for example.
For example, yeah. So, doctors in Alberta who told their patients that, this vaccine has limited benefits for you, they could be censored by, and in some cases were censored by their regulators. Because you're not supposed to say that, because that would tend to promote vaccine hesitancy. And doctors were not allowed to say something which would promote vaccine hesitancy. And if you said to somebody that, look, this vaccine has health risks, especially for, let's take an example, a young man, a healthy young man, it has a particularly risky profile for you. Again, the doctor being censored from being able to say that to the patient is a serious problem. It's a serious problem because you go to your doctor thinking that you can trust the doctor to tell you what is, in their view, the truth.
Mm-hmm. Does the bill deal with DEI or diversity, equity, and inclusion?
Yeah, it kind of deals with it in two ways. It has a series of principles it lays out, and it says no regulator can ever pursue these principles. I think the government's view is, and maybe many people's view is, that what those principles are is those are woke principles. And so effectively what the bill does is ban wokeness and professional regulation. And so DEI, wokeness, same thing, right? Um, if you actually look at those principles, and I've run it past a number of experts, those experts don't recognize those principles as being woke principles. So the principles don't actually affect the banning of wokeness. And DEI is specifically mentioned in the legislation in a couple places. And just like cultural competence, what it does is, on the one hand, it basically says, okay, you can't pursue DEI in certain respects. Ipso facto, you can pursue DEI in every other respect. So it actually, again, sort of in a backhanded way, permits and facilitates the regulators pursuing DEI in their regulation.
Okay. Oh my gosh. In a nutshell, because we are running out of time, but you are saying that the Alberta government needs to make 3 amendments to this. So right. Maybe quickly, what are the 3 that you're thinking there?
So the 3 are basically where they list all of those principles, and they say you can't do this, you can't do that. The other thing that they should say is any of the following principles, and then just lay out by name the specific schools of thought that are the problem. So critical race theory, like no regulator should be able to pursue critical race theory, post-colonialism, etc. So that's one amendment. Just specify those different postmodern ideologies that should have been prohibited in the legislation in the first place. The other one is they should only allow, there's basically in the legislation, there's a grant of power to mandate education. They should not be granting new powers to mandate education. They should be narrowing the rights to mandate education. And then finally, the legislation as it relates to the Law Society seems to actually exempt the body in the Law Society that actually has all of the power to do things like mandate training, called the benchers. So the legislation should not be exempting from the legislation the benchers. Although, because I'm of the view right now that the bill actually makes matters much, much worse, I'm quite happy that the bill exempts the decision maker in the Law Society from the bill, because I think the bill's a bad thing. So I'd like to see it not apply to the Law Society. But as it's currently drafted, it doesn't seem effectively to apply to the Law Society because it exempts the benchers.
Okay, interesting. What kind of responses are you hearing from your fellow attorneys and from the Alberta government?
Yeah, I think everyone's really excited to kind of get on the bandwagon and be excited for a great victory for freedom here. It seems like this is a win. People want to get behind it. I'm honestly having troubles convincing people that there's a problem. I've definitely convinced some people, including some heavy hitters. Basically, the people that spend most time thinking about the issue start to come around and understand that there's a serious problem. But yeah, it's a bit of an uphill battle.
Yeah. Oh, gosh. Thanks so much for sharing your thoughts with us today, Glenn.
Okay. Thanks very much for hearing them.
Glenn Blackett is a civil rights lawyer based in Calgary.